Good afternoon. Of course, it's still morning, 9 a.m. here in Honolulu, where I'm sitting in my chambers. The time difference may be one reason why people in Hawaii often just open up by saying aloha. So I will greet you that way. I'm Rick Clifton. I'm a judge on the Ninth Circuit Court of Appeals, and since the middle of last month, the president of the Federal Judges Association. I've taken over from Judge Cynthia Roof from the Eastern District of Pennsylvania, under whose leadership this program was actually planned. The FJA seeks to serve its members in many ways. Today's program reflects one form of that effort. It's the second of two programs this month organized by our Committee on Judicial Integrity and Independence, co-chaired by Judges Patty Saris from Massachusetts and Michelle Childs from South Carolina. Michelle, by the way, is now the president-elect and will take over from me in a couple of years. We owe them both our thanks, along with the other members of their committee. Judicial independence is critical to our concept for service as judges in the American system of government, but it's under challenge, as it has been at other times in our nation's history. The pandemic has prevented us from getting together, from gathering at conferences and FJC workshops and the like, as we normally do, to discuss that challenge. But out of necessity, we've all gotten kind of used to this kind of gathering via Zoom. So here we are. We've turned to one of our most distinguished alums to help organize this program. Jeremy Fogel graduated from Stanford and Harvard Law School, practiced in California, served as a state court judge, was appointed a district judge for the Northern District of California in 1998. In that capacity, he sat frequently with the Ninth Circuit by designation, and I had the privilege of sitting with him more than once. We became friends then. He was later went on to bigger and better things when he was appointed director of the Federal Judicial Center, I think in 2011. After retiring from that position in 2018, he became the first executive director of the Berkeley Judicial Institute at the UC Berkeley Law School. It's now my honor to turn the program over to him. Jeremy, the screen is yours.
Thank you, Rick. Aloha to you, and thank you for the very nice introduction. Hello to everyone. I'm sorry that I can't see you in person. I hope that it won't be too long until we can do that again. But I am really excited about being able to do this program, and I'm also very honored to have with me three terrific people who you get a chance to hear from individually, and then from the four of us together. And I'm just going to go around briefly and do a quick introduction of the panel, and then just say a few introductory words about what we're trying to do in this session. We'll hear from Chief Judge D. Brooks Smith. He's the Chief Judge of the Third Circuit Court of Appeals. He's been a very prominent and active leader in judicial conference work, as well as a fine chief judge of his court. I asked him in part because his court was at the center of some of the most contentious litigation around the 2020 election, which really brought a lot of judicial independence values into play. He's also somebody who really, I think, takes judging seriously and is not somebody subject to the kind of hyper-partisanship I think all of us have been concerned about. The next person we'll hear from is my former colleague and still my friend and Berkeley colleague, Thelton Henderson. He served on the Northern District of California bench for a long time and is a faculty member at Berkeley. Prior to that, was a faculty member at Stanford, and a very notable lawyer during the civil rights era, and has a lot of perspective, I think, from all of those experiences. So I'm really glad you can be with us. And finally, Dahlia Lithwick, who is a journalist who writes for Slate. She was also, is a lawyer and was a law clerk for the Ninth Circuit back in the mid-90s. One of, I think, the really insightful journalists about the courts, about the legal system, and really happy to have you with us also, Dahlia. Thank you. So before we start the actual conversation, I just wanted to say a few words about what we're trying to accomplish with this panel. The panel that was presented on May 3rd, that was moderated by David Levy, looked at judicial independence more on the macro level. What are the systemic threats to judicial independence? What are some of the international threats to judicial independence? How do the courts maintain their integrity and their role in our constitutional system of government in times that are really quite fraught? This panel is meant to be complementary to that one, and it looks more at the lives of judges, individual judges making decisions in individual cases, what we deal with in that process, what are some of the pressures we face, what are some of the values that we try to model and apply in making the decisions we make and in doing the work that we do. And in the second half of the program, I think we'll talk about how we can do perhaps a better job of getting the message out about those values, about what really makes the judiciary go and why judicial independence is so important. Because I think most of the people I talk to, and it's been especially true since I retired and have had more opportunity to speak with people outside the judiciary, people don't really understand what judicial independence is. They hear those words, judicial independence, and they think it means judges can do whatever they want. And that is hardly what it means, but it means something else. And I think we will talk about how we can do a better job of explaining what that something else is. It seems to me there are three values that are central. It doesn't matter what level you serve at. It doesn't matter what your judicial philosophy is. It doesn't matter what your personality or your temperament is. There's three values that are bedrock in terms of our understanding of an independent judiciary. One of them is that we are evidence-based, that when we decide cases, they are decided based on evidence. If there are disputed facts, we hear evidence to decide what the facts are and to make the findings that are necessary. And if there's not disputed facts, we still need evidence that then guide the application of the law. So the idea of having an evidence-based system is really a crucial one. And it's not true in every system. There are systems where the identity of the party is what matters. If it's the government, then that's the end of the story. You don't rule against the government. So the idea that we base our decisions on evidence. Second, we believe in procedural due process. It's important that people have a right to be heard, that before you decide a case, that the various interests in the case are brought to light, that the parties have a chance to make their view of the evidence, their view of the law known to the people who will be making the decisions. And that's another value that really characterizes an independent judiciary. And again, if you look around the world, not every system has that value. Not every system tries to practice that value. And the third one is we believe in the rule of law. We believe in accountability to the rule of law. So there's an ethical responsibility for judges to decide cases based on the evidence and the law. And of course, judges can see facts differently. They do all the time. Judges can have different interpretations of the law. They do all the time. And I think both of those areas of variability account for the variability in kinds of decisions that we get. So the fact that we get widely disparate decisions doesn't mean that those decisions aren't honest and made with integrity, nor does it mean that the fact that there's a lot of philosophical divisions mean that the people making those decisions are just making decisions based on their political views and not applying a process. You still have to base it on the evidence, you still have to base it on the law, and you still have to adhere to the process of deciding cases in that way. And if you go outside the lines too far, if you decide a case that's based on something other than the evidence in the law, the most obvious and most extreme examples of somebody pays you, or if somebody threatens you, or if somebody says to you, if you decide this case this way, you're going to be socially ostracized, or you're going to be attacked. And these are things that happen to judges, and we'll talk to this later. But the idea in our system in judicial independence is that we don't go there, that an independent judiciary requires accountability to the rule of law, and judges stay within the limitations of that. And we'll talk about that later too. But those are the three values, and you'll see that resonate kind of throughout the conversation. So let me turn now to Chief Judge Smith, and we'll talk for a little bit about some recent experience he had with respect to this. And just to set the stage, The Third Circuit ended up being ground zero for some fairly significant challenges around the 2020 election because Pennsylvania was a state that was hotly contested. It had the most electoral votes of the contested states. And several cases came to the Third Circuit and to the trial courts in the Third Circuit. And Brooks, I guess I'd like to just start by saying, what was that like? You know, you've been a judge for a really long time, and you were a prosecutor before that. You've had a lot of experience in the legal system. What was that like?
Well, we don't, of course, feel much drama nor ordinarily in chambers, at least not as most people would think of the concept. But having the need to decide cases that may have a significant, even decisive effect on the outcome of an individual state's election, and therefore the counting of its electoral votes, certainly gets one's attention, and it requires an all hands on deck approach in chambers. And certainly with the colleagues in this case on the Court of Appeals, a panel with your two panel co-members. And so it was an intensive period of time. And you've made reference to really what were two very important cases. I presided over both of those panels, wrote only one of the opinions. As you know, my colleague, Judge Bibas, wrote the other opinion, the second opinion, but both of these cases were decided within a short period of time, within a week or 10 days of one another, post-election. And so, yeah, it was certainly a pressure cooker in terms of time, and because the filings were coming in with a rapidity that defied even the ability to count them almost, and because there were numerous amici filing, there was pressure to hear oral argument, to extend periods of time, all with the eventual drop down date of the need to certify the election. So time and the need to produce as respectable a work product as possible would, I would say, have been the greatest pressures, not what most people would think, and that is the exogenous pressures of the importance of this case nationally. We recognize that, and I'm not suggesting certainly that this was just any other case, but I think the pressures that we felt were, to use the expression I've used with every team of law clerks I've ever had, and that is, our job is to get it right. I know that may result in a different ruling for one panel as opposed to another, or one judge as opposed to another. But by that I mean, we absorb as much as possible in the time we have of the applicable jurisprudence. We get an entire understanding of the record that's applicable, and we make our best call. That's trying to get it right. And so I don't think we did that any differently in my chambers or the other two judges' chambers in these two cases. But it was, I will make a confession. The second case, Judge Stefano's case, I had, thinking that things maybe were largely behind us, taken a few days down to Hilton Head, and much of some of my participation was done while walking the beach with a cell phone and an iPad. But that was as normal as it could get back then.
But that's, I mean, when you think about the way the story was covered in the media, you know, I'm not talking about Dahlia's media. I'm talking about just sort of the mainstream media, and the idea that this was really a big case and it could literally change the outcome of the election. What you just described was a very sort of ordinary business-like approach to doing your job and just figuring out. I mean, nobody questioned that the way you make the decision is you figure out what the facts are and you figure out how the law applies to those facts. That that's what you all were trying to do.
You used earlier the word process, which is something that the general public does not have sufficient appreciation for, and something I'm sure we'll talk about later. But in a process sense, we went about this in precisely the way we would have gone about any case that came to us, except that both were expedited in terms of the need to make a decision.
So two of your colleagues, well, one of your colleagues on the Court of Appeals and then a district court judge whose case you reviewed, both wrote, from my perspective, some pretty remarkable opinions about this topic that we're talking about today. Judge Bibas wrote a short and pithy opinion about you can't decide, no matter how important the case is, no matter how consequential it is, you still have to have evidence to support your claims. And Judge Brand, as a district judge in the other case, wrote a longer opinion, but it was essentially, he made the same ultimate point, which is you can't simply say, you know, the sky is falling. There has to be some evidence that the sky is falling before you come before a court and seek relief. When I read those opinions, I said, these are two very conservative judges, both applying the rule of law as straight as it can be applied. And to me, and I'm not saying this to make a political statement, but to make a structural statement, to me, that is really goes to the essence of judicial independence. That's what we ask judges to do.
It is, and I certainly was very proud of our court, and I have to say that court-wide, because in the case that I handled, we did need to circulate, albeit on a slightly truncated schedule, the opinion, because it was a precedential opinion, and pursuant to our IOPs, we have ordinarily an 8-day period for circulation, and there were no glitches along the way with that. The opinion that Judge Bibas wrote was a not precedential opinion, not requiring the same kind of circulation. Yet because of its importance, we did make sure it was circulated to the entire court before filing. But Judge Bibas said it so beautifully in the very first paragraph, his first few sentences of his opinion, which read, "Free, fair elections are the lifeblood of our democracy. Charges of unfairness are serious, but calling an election unfair does not make it so. Charges require specific allegations and then proof." We have neither here. Judge Brand, as you mentioned, similarly took on in great detail and with enormous patience a situation in a district court out in central Pennsylvania, Williamsport, where he is the lone presiding district judge. The case at the district court level, at the trial court level, and Mr. Giuliani appeared personally before him arguing that matter. I have never made it my practice to speak dehors the record or to in any way talk about a written opinion which speaks for itself beyond just quoting it. But what I will say, because it's in the public record, what was especially noteworthy, I'll say, was that the opinion decided, the opinion written by both Judge Bibas for our court and the opinion written by Judge Brand made clear that what was not at issue in that case was massive fraud. Judge Bibas says to start, note what it does not allege: fraud. That's not what was said outside the courtroom. That's not what was said publicly. And I'll say no more about what was said outside of the courtroom, but having a decision and the decisional process impeached by public statements of that kind certainly are unworthy of advocates who are members of the bar. And they certainly don't contribute to public confidence, which is much of what we're talking about here today, is an overarching area of concern and a basis for support for the very thing we do every day.
Right. So really, and again, I want to stress, I didn't ask Chief Judge Smith to talk about this because there were the political ramifications of the case. To me, these cases really reflected a commitment to a certain process, a certain set of values that I think the judges involved all made a tremendous effort to adhere to. Brooks, if you don't mind, I mean, you mentioned to me the first time we talked about this, you said, you made a comment to me, you said the center held the courts did their job. And I think that's really an excellent description of what happened. Let me turn now to Felton Henderson and explore another avenue of this. So Felton, can we bring up your, there you are. Okay. So Judge Henderson, as I said earlier, and I gave a very brief summary of some of his career, but I mean, he really has an incredible life story, including even being part of the Birmingham and Selma situation with Dr. King. He goes back a long, long way. And that history, Felton, when you became a judge, and you were one of the first African-American judges in our court and in the country, and having that history behind you, at that time it made you pretty different. I mean, regrettably, we're still not at a point where it's where it needs to be, but it's a lot different today than it was then. And you've shared with me some of the impacts that had. You had the same commitment to the same values as a district judge as we've been talking about, but you had a different life story. And I'm kind of curious as to how those things inflected, because people always say, well, you know, if you really have an independent judiciary, I mean, you have people who do very liberal things over here, and you have people who do very conservative things over there. And everybody's trying to apply the same principles, the same values, but you get very different results sometimes because of the different life stories that people have. So I'd be interested in your thoughts about that.
Well, I think, as you mentioned, being one of the first Blacks on the court, one of the first things I noticed was that there were some different expectations from me than the attorneys had for my colleagues. And one of the early things that happened was I would get motions for my recusal from counsel. And the argument would be that this is a discrimination case, with all due respect, Your Honor, and you're Black, and we very gently, humbly want to say, we don't think you can be fair in this kind of a ruling, and we'd like you to recuse yourself. And I developed a technique very early on for those kinds of motions. I'd say, well, let's see, okay, if I recuse myself, I'm the only Black on this court. Let's see, what will happen to the case? Well, it'll go to one of your colleagues, Your Honor, and they're white. Tell me why you think they can be fairer in a discrimination case than I can. But, you know, this was one of the early burdens that I had. And it was a challenge. It was also a challenge being Black at that time on the court. And as I was the second Black, you might recall, Jeremy, that Cecil Poole was the first. I replaced him when he went up to the Ninth Circuit. But I would also get hearings. To get to my court, you have to go up to the 19th floor and be out in the hallway and push a button next to my name. My secretary would ask what you were there for, buzz you in. You would go in for, say, a case management conference, and she would send you into the chambers. On many more than one occasion, attorney would walk into the room and I'm sitting there at the table, and I might be looking at some paperwork, and then I'll look up and say, yes, what's going on, or something like that. And the attorney would say, well, where's Judge Henderson? And, you know, and so there was suspicion about me that I was very aware of, and I tried to handle myself in a professional way and allay that. But this was an early concern with how I handle myself and how I would be perceived by the attorneys.
Let me ask you, so, you know, I think, you know, you're talking about experiences which thankfully I think happen less than they used to. They certainly still happen. And but it really serves to highlight how your understanding of factual things, not the law, but your understanding of factual matters was
Yes.
was different, right? Because you had a different life, you'd had a different experience, and one of the more notable cases you had in your career on the district court was the Proposition 209 case, and this was a initiative that was passed by the voters of California to abolish affirmative action, and
Right.
and that case was assigned to you. And if you can just talk to us a little bit. I mean, in terms of the values that we were talking about, we've been talking about here. You have your life experience, and you have the rule of law and the expectations of that. So talk about how those intersected for you in that case.
Yeah, it was a very controversial case. And I looked at it. It was newsworthy. It was on the papers. I was getting calls from attorneys to speak about, or from reporters. And I knew it was a big issue. And I actually had 2 law clerks at the time, and it's very rare that I would call both law clerks to work on this case. We'd sort of push everything else aside. And I decided that the issue, the main issue on the case was whether the burden, it was Prop 209, for those who don't know that case, was anti-affirmative action initiative that California passed. And so the issue I saw is whether the burden imposed by Prop 209 necessarily falls unfairly on minorities and women. That was the issue in my mind. And, I told my clerks that that's what I want to focus on. We'll focus on the issue and see if it does. And we did as much research as we can do, sort of like, not unlike what Judge Brooks decided, Judge Smith decided. We do our best shot at it. We look at everything there is. And I found a case, a 1981 Supreme Court case out of the state of Washington that said an initiative in Washington prohibiting school boards from ordering busing to solve desegregation was unconstitutional. I thought this case was quite similar, if not on all fours, and I used that as the main precedent. And so once I did that and looked at all of the other cases, I decided that Prop 209 had a likelihood of being found unconstitutional. It was a very interesting procedure. I look on that case with a lot of hindsight, a lot of regrets with the way it went, because it didn't take the usual path of an appeal up to a panel, a 3-judge panel. It went to a motions panel on the Ninth Circuit. And as you know, the Ninth Circuit has been viewed over all the years I've been on the case, on the court since 1980, as the most liberal court in the country. And I'm viewed as being progressive, or whatever they want to call me. And I took great comfort in knowing the likelihood of having a similar minded panel review my work. But this happened to be one of the few conservative panels, and the case died with that panel making findings. My long-term intention was to have a hearing on all of this and have some testimony before I proceeded, but we never got to that point because this panel essentially killed the case there. So
in about 30 seconds, what was their rationale for doing that? What did they think you had gotten wrong?
They thought I had ignored the main public presentation of what the case was about, and I was ignoring it. The state claimed that this was an not only was it not discrimination, it was an anti-discrimination case. It was it said that affirmative action itself discriminates against non-minorities, and that this was a statute to prevent discrimination. And they essentially chewed me out in very, very strong language, I thought, for not abiding with that and siding with discrimination and saying it's okay to discriminate against people and allow this unfair affirmative action. That was the
Yeah. Well, it's the reason that I wanted to ask you about this is that, we certainly see echoes of these arguments today, but it's also the case that I think if you talk about judicial independence and judges being committed to doing things in accordance with a certain process and based on evidence, it doesn't. You're inevitably going to have situations where judges will look at the same case. They'll look at the same exact proposition or the same exact litigation, and they'll see it quite differently. They'll have different starting points. Their life experience will give them different perspectives, and that's how we get the variety that we get. And that's how something like the Prop 209 case could have happened the way it did. But it wasn't a case of Judge Henderson just kind of going off and doing whatever he wanted, or the motions panel doing whatever it wanted. It was a lot subtler than that. And I think this is a good case study.
That. And I had, the lunchroom there that we have at the court. I was very lucky. Very early on, I came to an understanding of how that plays with us. One of our senior judges at the time was in a trial and came down from the lunch break, and we were in the lunchroom and said, how's the trial going? It was a discrimination trial, employment discrimination. And I remember this very clearly. And I was brand new at that point. I'd been on the court maybe 6 months. And he said, well, it's going very interesting. The plaintiffs testified today. And they were saying that in the locker room where they go in to change their clothes before they go out into the field, that some of the workers were painting the N word on their lockers and around the locker room, and they were hanging baboons over the pipes there. And I got very interested and I was listening. And then he went on, and this was a good friend of mine and a fine man, a fair man. And he said, and I don't know why they feel they have to exaggerate like that. They've got a good case, and I don't understand why they have to. And all I could think of was that I grew up hearing my father and my uncles tell those very kinds of stories about the workplace. And I came to an understanding of the difference between me and this man is that our experience, we bring something different to the bench. And I readily recognize that kind of discrimination, whereas another party would have a hard time getting this particular judge to recognize it. And that's sort of what we bring to the bench.
Yeah. Well, I've written, now that I can be more outspoken than I used to be. I mean, actually I've written about this in the context of of George Floyd, and how people who didn't believe that something like that could happen, once they saw it on video, it was a bit of a paradigm shift, more than a little for some people.
Exactly. Yeah.
So let's move on now. We'll come back, Theldon, and thank you for sharing those stories. They're very, very illuminating. Let me turn to Dahlia. And so Dahlia, you used to work in the courts. You now are a journalist who covers the courts. So this idea of what judicial independence is and how we talk about it. How do you see this?
First, I want to say thank you and how honored I am to be on this panel with Chief Judge Smith and Judge Henderson and with you, Jeremy. And I also just want to say, I always say this, I'm completely off the record right now. I'm not reporting any of this, anything that is said or put in the chat. I want to be a resource to you. And so this is not me wearing my reportorial hat. I think my answer to your question, Jeremy, is that I'm really struck by one amazing tension between what we just heard from Chief Judge Smith and from Judge Henderson. And that is this amazing quality of the judge doesn't matter. The identity of the judge doesn't matter. The system is the system, and the rules are the rules. And at the same time, as you just heard so eloquently from Judge Henderson, of course, the judge matters. Who the judge is matters, and their experience and their backstory matters immensely. And so what do you do about the fact that in some sense, we want to tell one story about the judiciary, which is these are brains in a vat. The minute they take their oath, they become, umpires, to use Chief Justice Roberts' construction, and any element of personal narrative or history falls away. And at the same time, we all tell the story, not just us in the press, but as you just heard from Judge Henderson, that who you are matters and how you think matters. And I think that it's really, really hard to hold both ideas in your head at the same time. And I say this as somebody who, covered the Supreme Court for 20 years. And every time I wrote an article, my editor would say, put in Clinton appointee, put in who appointed them. That's essential information. And I would always have this fight because I know that who appointed you tells something about who you are as a jurist, and actually tells much less than my reader thinks. And so I think we're always on the seam of this problem, and I always identify it. One of my favorite books on this was by Keith Bybee, who teaches law at Syracuse, and he has this terrific book called All Judges Are Political Except for When They're Not. Mm-hmm. And to me, that is kind of the best encapsulation of how you tell this story, that simultaneously, it must be true that the judiciary is an independent branch. It is unlike the political branches by design. What it does is fundamentally different from what the political branches do. And at the same time, there are valences around it that are personal and political and biographical, and that we have to figure out, particularly in the press, where there's such a strong impulse, as you heard from Chief Judge Smith, to just tell the political story and to tell it, as he said. I was so struck by him describing the imperatives in those election cases to do really complicated work quickly. Those are exactly the journalistic imperatives. We have to do very, very, if we're doing our jobs correctly, complicated work very fast in a compressed amount of time. How do we tell a story about judicial independence in the face of all those complicating factors of politics and biography? And how do we do it in a way that helps the public understand that both those things can be true, and also that the judiciary itself is just not going to be subject to the same metrics of a purely political story? So I guess what I'm saying, this is a long answer, but how do you convey that something is something and also its opposite at the same time? And how do you do that at its worst in a tweet?
Yeah, and that's, because it's not, I don't think it is something you can do in a tweet. I've been thinking about this now for a couple of years, and I think I can say, we have these three core values, evidence-based, procedural due process, and adherence to the rule of law, and ethical consequences if you don't. So that's all there. But then you still have to talk about the particulars. And each one of those particulars has nuances to it, right? So fact-finding, I think Felton just shared with us exactly how fraught that is. Because we're bringing our life experience to the process of fact-finding. And so what we are willing to believe, what significance we attach to things, all of that is affected by who we are. And so the way we find facts and the way we see facts, how much procedural process we give people. Everybody has a basic right to be heard, a basic right to participate and so forth. But what does that extend to? I mean, does that extend to listening skills? Does it attend, how much time do you give people? I mean, how much allowance do you make for people, for instance, who are, say, unrepresented or something like that? I mean, there's all these questions around process. And then, in terms of coloring outside the lines, you don't get to do that. Well, where are the lines? I mean, how far can you go? And when has a judge simply gone too far and become unhinged from the core values? And so none of those things are tweetable, right? I mean, and yet, I mean, you're saying, and I think all four of us would say, it's not like the other branches. There actually is a there. A book I really like about this actually is by Professor Charlie Jay from Indiana University, and it's called Courting Peril. And he essentially said the same thing, that we're not going to convince anybody by calling it impartial umpire calling balls and strikes, because nobody believes that. But it's sort of equally untrue that judges just do whatever they want. So, and even the chief, I'll say, I mean, if there's any people from the First Circuit here, I think at one of the conferences a few years back, I just remember there was like 10 feet of snow on the ground in Boston, but he said, umpires have different strike zones. That if you go to a baseball game, that different umpires are going to have different strike zones. So that there's at least some acknowledgement, and I think he certainly is right about that. So, given that it's that kind of nuanced analysis, I mean, you have other thoughts about how to talk about it?
I mean, I feel like today is my day of competing imperatives. I feel like on the one hand, I really want to say that there is such a tendency to blame the media. And part of that is right. And we should talk about it is absolutely factually true that even in the 2 decades I have covered the courts, we've gone from having 8 hours to read and digest an opinion, 4 hours to write about it, 3 layers of editors to read it, somebody to fact check it, and time to post it, to quite literally, there's simply no, and I know you all know this, the media doesn't work as it worked before. And I could tell awful stories that would curl your hair about the ways in which on a Sunday, when you want that long reflective piece, what did the Second Affordable Care Act hold? How does it change things? To have your editor say, oh, that was so 4 days ago, we've moved on. So I think that we have to sit in the knowledge that the news cycle has changed and the economic incentives have changed. And like I said, we can talk about that. I know you're all manifestly aware of it, but I also want to be clear that the courts were being misunderstood and misrepresented by the press since the time of the founding. And that it's really, really easy to say, the press now is spectacularly apt to get it wrong. But the truth is, the press was always spectacularly apt to get it wrong, to misrepresent, to sensationalize, and to distort. So with, again, those as the goalposts, I would say that one of the things that worries me is that I think we in the press have lost the ability to do something that takes an immense amount of time well. And with a lot of exceptions, and I do not want to throw my colleagues, by the way, I think the Supreme Court press corps continues to be the most sober, thoughtful, reflective press corps I've ever seen. But the fact is, the vast bulk of Americans don't read from Adam Liptak and from Marcia Coyle and from David Savage anymore. What they are getting is third-hand sources that are up on Facebook. They're getting their news from TikTok and Instagram. So to the extent that I think my colleagues try really hard to get it right quickly, I think that, and you were probably hearing some of this from Chief Judge Smith, the fact is it's out there, and it's out there being portrayed and represented and manipulated by forces that have never set foot in a courtroom and couldn't check a site if they were paid to. And so I think one of the problems we have is that the extreme specialization around court journalism has almost completely become irrelevant.
Well, that's a great setup, Dahlia. Thank you it's a great setup for our roundtable discussion, which we're going to go to now. So, so here we are, we have the federal judiciary, which has this long tradition of independence and takes independence very seriously. We have an environment in which the media, as Dahlia said, has really changed. And so the chances of getting the kind of deep and thoughtful coverage that we got at least some of the time in the past has become even less. I mentioned recently that when I was a state court judge in San Jose, California, there were actually 2 beat reporters from our local paper that covered the courts. There was a state court beat reporter and a federal court beat reporter. Now there is no beat reporter. There is an all-purpose reporter who covers courts and several other things as well, and just doesn't have the relationships or the knowledge. So I guess my question is, we have a problem. What can the judiciary do to begin moving toward a better understanding? Because I think the purpose of both of these programs, I think the FJA's goal in both programs was to talk about threats to judicial independence and what the judiciary can do to address those threats. And here we're talking about, we have a really good product, I guess, if we want to use that word. I mean, we have an institution that takes itself seriously, works seriously, has values, tries very hard to get it right, as Chief Judge Smith described very well. I mean, that's what judges do, and that's what they do over and over and over again. And that story is not getting told, right? So I guess what I'd like to do is, Dahlia sort of described a challenge for us. I mean, what can the judiciary do that it's not doing to get a better picture of this judicial culture out to the world? So let me turn to my judicial colleagues and just see if either of you have any thoughts about that.
I'll defer to Judge Henderson to go first.
Go ahead, Dalton. Yeah.
Well, one thing that we can do, and I did it because a colleague of mine convinced me that it was a good thing to do, is get a better view of who we are. And one of the things I would do for that, and you mentioned it a few minutes ago, Jeremy, you have pro-pers. You get a lot of pro-pers. And I was always a bit distraught when a colleague would say, oh, we have this kind of a case, or we have a pro-per case. And yeah, I gave that to one of my law school interns to handle and work on when I have a big case here, and now me and my clerk's going to work on it. And I made certain that I tried that everyone who came into my court felt they had a fair day in court. And I would call them, I would listen. And one of the things I think a lot of our colleagues don't understand is that very often some of these pro-pers, they just want a fair hearing. You listen to it and you explain to them, well, you don't really have a cause of action and I'm going to dismiss this, but let me tell you why, and let me spend some time with you. And I can't tell you how many thank you notes over the years I've gotten from the losers saying, thank you so much for hearing my case. And I think that's something we can do that puts the word out that we're not robots. And I mentioned the robot because that's the only way to stay with the umpire analogy. You're going to get a true calling of whether a ball is a strike or a ball is half a robot. But we're dealing with humans in the umpire world and put out the word that we are human. We're doing our very best, and over the long haul, this system works. And we were talking before we started the program about going to other countries. And I did a lot of that for years. And I probably have been seen over the years as a critic of a lot of things in our country, especially as they pertain to race and class. But I always came back from these countries with a greater appreciation of our country, we really do have a good system, and we need to let that be known. We are really doing our best. It is fair. It's not corrupt. And you may not agree that that ball on the outside corner was a strike, but it was the best call that guy could give, and he wasn't cheating.
You're really talking about each judge having it be his or her part of his or her role definition to do that kind of education in the courtroom.
Yeah.
by how people are treated, by how process is observed.
Yeah.
This was something we did a lot of work on when we were curriculum building at the FJC a few years ago. Is that in addition to being a good legal analyst and a good writer and the obvious things that judges have always been expected to do, you need to be a good listener. You need to be a good communicator.
Absolutely.
You need to be able to allow people to feel that you, in that moment, that you care about them. Not inappropriately, but you care about them in the sense that you have fellow feeling for them and you're trying to understand what's bringing them to court. So that's what you're saying. And you're saying that judges have an opportunity to do that every day through their demeanor and the procedural process that they observe.
You just used the words, Jeremy, trying to understand. And I think that really puts the finger on it. I certainly agree with everything that Felton has said. First of all, that we do have, for lack of a better characterization of it, a product to sell, if you will, a story to tell. We are a system almost devoid of corruption. I'm referring to the federal judiciary, and I'm very proud of that as an American and as a federal judge. Another part of your question was, how do we go about explaining this? And I find that a really vexing question these days. I do want to, I won't say correct something, but to the extent that Dahlia thought that I was describing a process where who you are or what you came from, or even how you identify in some ways, doesn't have anything to do with how you go about making a decision. I'm not that naive, but I think too many critics of the judiciary tend to overlook one thing, and that is that whatever it is justice is, whatever it is we are doing that we call judging, has a huge aspirational component to it. Irrespective of who we are, what we are, where we came from, we're aspiring to do something. And as I was off camera, I reached over to one of my bookcases and pulled out Learned Hand's The Spirit of Liberty, where he said, "What then is the spirit of liberty? I cannot define it. I can only tell you my own faith. The spirit of liberty is the spirit which is not too sure that it is right. The spirit of liberty is the spirit which seeks to understand the minds of other men and women. The spirit of liberty is the spirit which weighs their interests alongside its own without bias." Do we have the biases? Hell yes. Can we rid ourselves of all of them? Absolutely not. But we can aspire to do that. And I just close these comments on one anecdote that occurred to me when I was a state trial judge. I hadn't been on the bench too long. I was trying a murder case, and it was being tried by someone who had been an assistant of mine when it was the district attorney. I can't remember what the objection was, what the evidentiary issue was, but we were at sidebar, and there was passionate argument on both sides. And my former assistant argued to me. She said, "Well, that's not what your view was when you were in this office." And I said, "You're damn right it isn't, because I'm not in that office anymore." Sometimes you can learn from experiences that will necessarily dictate a different result than what some might intuitively expect is going to be your result.
Yeah.
It's not a deterministic process necessarily based on what your experiences are.
That's right. So I have a question that I think we can all talk about, but it's a question that grows out of a conversation that Dahlia and I had when we were preparing for the panel some weeks ago. So what you've talked about, what both Felton and Brooks have talked about is in your judicial role, doing the job in a way that conveys fidelity to these values and conveys respect for people who are appearing before you. absolutely fundamental good thing. I mean, it's totally in line with what we're talking about. The question is there some need to or value in taking it a little bit further, being more proactive, being more public? And of course, you've got canons you have to think about. You have the code of conduct. You can't talk about cases. You can, under the canons, educate the public about the legal system. In fact, there's an affirmative endorsement of that in the code of conduct. But in my experience, judges are reluctant to talk to the media. There's varying degrees of reluctance. I mean, some people never do it. Some people do it, but only under very limited conditions. And then there's people, and I put myself in that category even when I was sitting, where I actually spent time with reporters, and we just didn't talk about cases. We talked about the process, and we talked about what was going on in the courts, but it was all under not off the record, not for attribution and by way of background, but it was more as a way of educating and building up some kind of relationship. And I guess my question is this something, given where we're at right now, given what Dahlia was describing earlier in terms of the limitations of the media in reporting what happens in the courts in a way that's actually accurate and educational, should the judiciary be doing more? So let me ask you that question first, Dahlia, and you could talk a little bit about this because I know you have a view of it, and then I'll ask the judges what they think.
I mean, I think I would just say, and again, over 2 decades, I've seen such a profound shapeshift. And when I talk to judges, almost unerringly now, they say to me some version of, when I first came to the bench, there was one dedicated court reporter, and she'd been, on the beat for years, and she knew the marshals, and she knew the bailiffs, and she understood, the difference between an arraignment and a sentencing. And now what I have is the guy who read the weather last week, and next week he's going to be hosting the baking segment of the show and make cupcakes. Like, they don't understand the system. I have no relationship with them. And my answer to all of that is true. That the era of the dedicated court reporter who really understands the system and understands the values that Jeremy opened with is over. We just have to live with that. It's not coming back. And that I think that one of the things, and I suspect this is what Jeremy was setting me up to do, that can serve as a corrective for some of that is for judges to find a way to open that channel and to be resources, whether it's the court acting as a resource or someone in the PIO acting as a resource, but somebody to help some reporter who's got a filing deadline in 2 hours and quite literally doesn't understand the difference between a civil trial and a criminal trial. How do we do that? And I realize that's completely unreasonable to burden the judiciary and in addition to everything else with this sort of obligation to explain. But I also think barring that, what rushes into the vacuum is politics, and is the sort of, if it bleeds, it leads impulse to tell very, very, very graphic stories about conflict. And so I think the only other thing I would say, because I actually would rather hear from the judges than from myself, but we opened this panel talking about the elections cases, and I'm seeing in the chat a lot of questions. How do you get 60 elections cases and still have a third of the country not accept those rulings? I actually think, and I think Chief Judge Smith started with this, the story of a not story is an amazing story. In other words, the triumph of those cases is not simply adherence to the rule of law, adherence to principles of evidence and norms of how we do this. I think that by draining the drama out of it, in much the same way, by the way, that state election workers drained the drama out of it and just rose to the occasion by sinking under the drama bar, I think that's a really useful model. And so as much as the journalistic credo here is show, don't tell, I think by simply showing we are doing excellent non-ideological, non-partisan, superb work that speaks for itself within the four corners of the opinion, that goes a long way to achieving the outcome you're asking about. I think the harder you work to publicly perform independence outside of the judicial role, the more you raise questions. And so I guess I'm saying, like, kill them with boringness. It sounds like an incredibly unsatisfying solution, but I think it gets you part of the way there.
Well, so let me ask you, and this kind of grows out of my personal experience, but I'm sure my colleagues will have thoughts about this too. So I had a number of very controversial cases when I was on the district court, and I was quite aware of the controversy, and I was getting the pre and post decision emails and phone calls and everything else. Twitter didn't exist then, thank God. But when I wrote those opinions, I usually would start with a paragraph or two, just saying, I understand that this is a huge deal in the court of public opinion. Here's my job. My job is not to resolve those kinds of moral and political conflicts. My job is to figure out what the facts in this case are and how the law applies to them. And here's what that process gets me. So it's sort of a hybrid of what you're saying, but it was also starting right out and so sort of owning the fact that somebody was going to write about this case and say, well, he was appointed by President Clinton, and therefore he did X, and so I thought it would be good and would be completely consistent with opinion craft to say, here's what the case, here's the context in which the case is arising. Actually, the case isn't about that, right? The case is about this much narrower, discrete legal issue. But of course, people are going to think that I'm commenting on this other stuff. And so I'm going to make very clear right now, I'm not commenting on this other stuff. So Thelton, Brooks, is that something in the cases you've had? I think Judge Bibas actually, in a very economical way, did take that on in his opinion. The first paragraph that you read earlier, Brooks, that's essentially what he was doing. So here's how we got here. Now here's what the record shows, and here's where the law takes us. So what do you think about that as a thing that judges could do more consciously?
I think it's well advised to do so, and I do it often. I will explain, here's what I'm doing, here's what I'm trying to achieve, and here's the way I'm going about it. And also, here's what I'm not doing. Here's what I'm not considering, although I understand it has a place in here somewhere, but I'm shoving it aside because it doesn't go into the merits of the ultimate ruling that I'm going to make. I think it's very well advised to do those kinds of things. Speaking to a question you raised earlier, I think it's also, and this is just my view of things, I understand that, but I think judges are often too distant. I can't talk about this, I can't talk about that, and and not humanizing themselves, even to the press. I got along well with the press, and I enjoyed it. I'll remember named Herman Mintz for many years.
Howard Mintz, yeah.
Howard Mintz, who was
right.
A reporter that I love to talk to. He always wrote a fair story. He worked hard, and I've been retired since 2017. And about 2 weeks ago, I got a call from a reporter that I'd worked up a friendship about this controversial ruling by one of the judges about criticizing the press, very strong criticism, asking for my ideas. And that's, and I think it spoke of the friendship that we had and the way we depend upon each other to get out our story. So I would encourage judges to be aware of the ethical guidelines and all, and don't talk about confidential things. But there are ways to relate to the press that would benefit our image in many ways, I believe.
There certainly are ways, and I agree wholeheartedly with Felton that we need to do more. Numerous courts have had programs called Judges and Journalists programs. The Third Circuit has done that. I'd be interested in hearing from Dahlia as to whether she thinks programs of that have some value. I personally think that they need to be very interactive and not, as some have actually been called, law school for journalists, which I think is a little pretentious, at least as a title, but something that truly allows a sharing between journalists as to the challenges that they face, especially in the economic models that exist now that have driven them so much toward the need for immediacy as opposed to real, sometimes quality content, and allowing us an opportunity to give our side of the story and indicate some of the pressures and exigencies that we face in our work as well. I don't think that compromises. In fact, I'm confident that doesn't compromise any of our ethical prescriptions. I think it can result in some ongoing relationships that can be mutually helpful. I know that I developed at least one of those with a reporter for a print service. And in fact, that person and I texted just today on a matter. So there are ways of keeping that kind of communication line open. And I think it's valuable. I understand the resistance of some to it, but I think we need to do it more.
Well, let me.
Sorry,
Go
can I?
ahead. Yeah, I want to. There are a couple of threads of questions I really want to get to here in the next time we have. But go ahead.
I'm going to take 30 seconds and
Gotcha.
just say, I think that one of the themes I'm hearing really being reinforced is that actually journalists and judges have incredibly congruent interests.
Absolutely.
And that there is a way for this to be kind of Pareto optimal, or there is a way for this to be adversarial. And it seems to me that a lot of the anxieties when we talk about judicial independence are the same anxieties we in the press have about, failing trust in institutions and really destabilized notions of truth and truth finding. And so it just seems to me that rather than starting from this oppositional view, to understand we're almost completely aligned and work from there.
Well, there's two things I love about what you just said. First of all, Pareto optimal is one of my favorite concepts. We use it in mediation training all the time, so thank you. But secondly, and more seriously, the truth gap. I mean, the idea that both the institution of the media and the institution of the courts, apart from just the problems we've been talking about, that there's a much bigger problem, which is that we're in a society where a significant number of people don't read newspapers. They don't believe that the courts are worthwhile. I mean, they believe a lot of stuff that's very antithetical to what we're talking about. And several people have asked in the chat and in the Q&A whether there's anything we can do about that. I mean, whether this whole conversation that we're having is great if you're already part of the group of people who believes in evidence and in so forth, but that there's one of the real structural problems we're facing in the country right now is that there's a lot of people who do not live in that world apparently. And so I think we ought to talk a little bit about that. And then sort of, it seems to me the other side of that same coin actually is another question we got about whether there's a role for judges to talk about some of the inequalities in society. I mean, to talk about racism, to talk about sexism and gender bias, to talk about bias against LGBTQ people and so forth, whether that's something that there's a role for judges to play a role to do some leading and talking about. And that's a tough one given the ethical canons as well. But it's one that came up with the Floyd murder and actually some courts did speak out. So I mean, it's two different questions, but they seem to me related to each other. And I guess the first one, which a number of people raised in the chat and Q&A, is, we've had a good kind of collegial friendly discussion about courts and media and getting the word out and educating about what judicial independence is and what it isn't. What do you do with the fact that apparently there's a significant percentage of our body politic that's just hostile to institutions, period? Is there anything we can do about it?
Outlive it.
Okay.
I don't know.
Yeah, it's not something that there's a, if you knew the solution, you wouldn't be talking with us right now. You'd be talking to the president or somebody about it. So, but, and has anything occurred to you? I mean, Brooks, you and I've talked about this. You're from a part of Pennsylvania that
Yeah.
is the, it's the Alabama in between Pittsburgh and Philadelphia,
That's how James Carville described it, and it is. I don't want to get too, I don't want to get partisan, but there is all too much evidence out there that one passes that suggests that there's still an election campaign going on. This is disturbing. This is alarming. The denial of some things that we all know to be fact, hard-bound fact, is very troublesome. And I'm not sure that we as lawyers and judges are professionally equipped to deal with the underlying, I go so far as to say in some cases, pathology that leads to that sort of denial. I truly don't know what to do about it. On the other hand, I certainly don't want to give up on it. And I think we need to continue to do as much civics education as we can participate in. And a point you made previously in our preparation, Jeremy, is maybe we need to be very careful about our terminology, and that is, from a public standpoint, instead of talking so much about the concept of judicial independence, which may be misleading, let's talk about the rule of law and what that means.
Mm-hmm. That there is a culture, there is a code of conduct, not just the ethical code of conduct, but there's a code of how judges make decisions and how judges analyze things that's serious, and that judges have aspired to follow for 200 plus years, and we need to make that point better than we make it. Felton, what are your thoughts?
Well, one thought I have, I agree with everything that Brooks just said and what you just said, Jeremy. But I think another thing that we could benefit from is, oh boy, sorry, I've lost my train. Oh boy, I'm at that age now, and I apologize.
Okay.
I'll come back with it. It seemed important
Delia?
at the time.
I feel like Jeremy's heard me say this, but I'll say it. I feel like my credo for the last few years, and this question of what do we do about so many folks in the chat and the Q&A are, really surfacing this anxiety about, as long as media is entertainment and as long as clicks are being rewarded, I hate to be the bearer of bad news, but it's going to get worse. I've heard it say that in the next 2-3 years, any news that you're not paying for will be fake. In other words, everything that is true will go behind a paywall. And we're going to have deep fakes. We are going to have the ability in a very short amount of time to have videos that we cannot discern whether those are true and not true. And so the news in some sense is bad. And I think if you have a polity that's starved for conflict and for nihilism, it's really hard. Even civic education, I don't know if it gets you past that, but I do this goes back to my sort of credo of the last few years. I think Jeremy has heard me tell the story of how we were living in Charlottesville in 2017 when the Nazis marched, and my then 11-year-old son said to me, what do you do if you go out and you fight them on the streets? You lose. If you stay home and ignore them, you lose. Any engagement or lack of engagement seems to get you to the same place. And I think that that's so apt, even in this context. What do? Do you tell people who are lying about the outcome of the elections cases that they're lying liar? No, you can't engage with it. Ignoring them allows it also to live in the world. And I think the paradox is that people are starved for adults. They are starved for institutions. They are starved for norms. And so I'm not entirely being fatuous when I say I think part of the solution is to bolster norms, is to bolster, really just basic adult civic behavior, and to understand that there's something being modeled here that people are absolutely starved for, and to give in to kind of Punch and Judy antics, even around supporting the judiciary, is to already lose.
Yeah, and I'll just jump in. I'll take my moderator hat off and just say what I think here. I mean, it's easy to get very discouraged. I mean, I read these questions and I can feel the discouragement and the concern people have, and it's totally justified. I mean, things have been pretty awful in this particular context. I can say that doing something to push back against it, kind of in the way that you described, Dahlia, has helped me deal with that in my own life. Is it going to be effective in changing things? I don't know. But if you're putting good energy back into the world, if you're putting truth back into the world, if you're supporting institutions that you care about, it doesn't hurt to do that. And I think it's better than being completely passive. And I'll sort of two examples. I've been doing a lot of speaking to non-lawyer adult groups. So it's not civics education in schools. It's like finding, Rotary clubs and Kiwanis clubs and people like that. And just talking about what we've been talking about on this panel, what is an independent judiciary? What isn't? What is it? What isn't it? Let's talk about the election cases. And they'll ask me stuff like, what's the Chief Justice like? What's Justice Sotomayor like? So I mean, people have all sorts of questions. They're curious. And so just a chance to talk about that, I think helps. But I also think, and this gets to the second question, which I don't want to lose, when the events occurred in Minneapolis and in Louisville last year, I felt it was important to say something. And I know a lot of there were, I think, about half a dozen or maybe even more than that, chief justices of state courts who made statements. There were 3 state Supreme Courts that made formal statements saying, we're not talking about individual racism or individual anything. We're talking about our history, that our country was founded on inequality, and there are still ways in which inequality persists. And we as courts and judges in courts need to recognize that those structural factors are present. We still have to decide cases exactly the way we've been talking about. You determine facts, you give people due process, you apply the law. That doesn't change. But the lens through which you look at it has to change, because to not recognize this, I mean, people of color could not serve on juries, women could not serve on juries, and well into the 20th century. Jury trial is sort of a bedrock of our system. So, just things like that. To be able to say something about it, it's empowering individually, because you don't, you're not losing your voice, and it's empowering in terms of the way the values you just talked about. And of course, the hard part, if particularly you're an active judge, is figuring out how to do that in a way that complies with the code of conduct. And it's a thin ledge, but I think it can be done. Felton, did you think about what you were thinking? Yeah, go ahead.
Yeah, let me take another stab at it.
Yeah.
I have always taken great comfort in the fact that there's a Ninth Circuit appellate court to review my mistakes. And I make mistakes, and I've never met a judge who was on the court for any length of time who didn't, and you get reversed. I don't think the public understands this. If Felton Henderson does something that they think is stupid and unfair and biased, that's not the end of the world. There's another court that will review that will have more time than I had and will get it right. And if they don't get it right, there's yet another court. And I think the public needs to know that there's a process. It really is inherently built for fairness and correcting along the way. And I don't think the public understands that. And one of the first things I tell my clerks along the way is that all of us should take great comfort in that. We may get reversed along the way, but there's another court there that's looking at it very carefully and very fairly to get it right. I think the public needs to know these kinds of things. And I'll repeat myself by saying that I think that all of us, given the state of conditions now, should think about spending a little more time talking to civic groups and humanizing ourselves, and leaving that group saying, God, that guy or that woman, I think really represents fairness there, and I need to look at this differently.
Putting ourselves out there. Yeah.
Ourselves, exactly.
Okay, well, thank you, Felton. And we're almost out of time. I want to just, Brooks, I want to give you an opportunity if there's anything you want to add based on what we've been talking about in the last few minutes.
Just that to follow up on precisely what Felton just said, we need to spread our message, and our message is that we are about law, as Justice Scalia is so often quoted as having said or written, a rule of law is a law of rules. It struck me when I read just a weekend or so ago the recent book that John Boehner has published, and I don't expect that it's going to win a Pulitzer or any prize that is based on style, but highly anecdotal. And one sentence that really caught my attention. He writes, anybody who says there are rules to the political game is probably not very good at playing it. Rules can hem you in. That's the political game. That's not what we're about. And that's a message that I think we really need to carry forward.
Mm-hmm. Yeah. Yeah.
I think I would just say this, in the weeks after Justice Scalia died, and then again in the weeks after Justice Ginsburg died, the thing I was asked most frequently in media appearances was about the nature of that friendship. And everybody thought it was pretend, and everybody thought it was put on for optics. And I have said, and I will for the rest of my life say, that was an authentic friendship. And it was an authentic friendship in no small part because these two people who could not have been more different really took each other as being first and foremost in good faith. And just to go back to, where I think Chief Judge Smith started, if you assume that you're starting with facts and law and evidence, all the disagreements in the world are orthogonal to that. I think law really is one of the very few places we can say that it's tethered first and foremost to the presumption of truth and the presumption of good faith. And then we can fight about everything else. I really think there are very, very, very few professions that model that better than the American justice system. Mm-hmm. And I think at this moment, as I said, when people are starved to see that modeled, now is exactly the moment we have to really, really sort of let it shine. And if that means talking to civics groups, if it means taking calls from annoying baby reporters and explaining for the 400th time, all of that, I think, matters now more than ever.
Well, I could not agree more. I think I've made that clear. But one of the things that I've learned in my post-judicial life is that just what you said, people are starved for this. People want to know. They have all kinds of questions, and they're not the questions we'd get if we were speaking to a bar group. They're I mean, it really is like, what's the Chief Justice like when he's off the bench? I mean, it's stuff like that. But, that's important. And getting ourselves out there as sort of measured, thoughtful, values-centered people committed to values. That's a very positive thing, and there's a kind of cynicism or sense of desperation or sense of despair that we feel, I think, at times. I certainly can acknowledge that. Last year was a tough year with the virus and with political environment and everything else. But to be able to put out to tell the good story that we have to tell is a really, really powerful tool and should not be underestimated. I just want to put in a 15-second plug for a program that Berkeley Judicial Institute is doing tomorrow on collegiality, how judges can build relationships. You mentioned Justices Ginsburg and Scalia, how you can develop a kind of bond with colleagues and a common purpose with colleagues that can get some of this work done. And The two presenters are Bernice Donald from the Sixth Circuit Court of Appeals, who's done a lot of work in this area. He's kind of a national leader in a number of areas. And Judge Kevin Burke from the Hennepin County Superior Court, which was, of course, where the Chauvin trial was, and was he didn't try the case, but he was very much involved in some of the goings on around it. And they're presenting together at noon Eastern tomorrow. If you just go to the BJI website, you can register. So it's just another learning opportunity. I want to thank FJA for giving us this chance. It was good to talk about this stuff. It's always wonderful. I mean, I'll just say for me personally, to see the three people I got to do this panel with. I mean, I just have the utmost respect for all three of you, and I really want to thank you so much for putting in the time to do it. And I hope it was valuable to the audience.
Very worthwhile.
Yeah.
Thank you so much.
Yeah. All right. So everybody, stay safe, be independent, and represent the rule of law. And we'll see you around. Bye, everyone.
Bye-bye.
Thank you. Bye-bye.
So if we judge this program by the standard Dahlia said about killing us with boringness, it failed completely. The FJA wants to thank all of you for participating. This is a kind of discussion we need to continue, and we will try to continue it. When we're able to resume contacts, you're going to have your circuit conferences, you're going to have your FJC workshops and so forth, but the FJA is going to continue to participate as well. If anybody has suggestions for programs you want us to pursue, please send them to me. You can find my email address on the JNet because I'm in that judiciary network too. I'll also remind you that our quadrennial conference, to which all members are invited, is less than a year from now, May 1st through 3rd of next year, and we intend to have programs like this there as well. So with that, let me thank the panelists once again, and we look forward to seeing you down the road. Aloha.